Welcome to the Faculty of Law, University of Lagos channel. In the last video, we spoke about the tort of private nuisance. This presentation therefore examines the defenses and remedies to the tort of private nuisance. My name once again is Professor Adekile. The defenses that we'll be looking at today are three. We shall be looking at prescription, statutory authority, and planning authority. Prescription. The defense of prescription occurs where a defendant proves the acquisition of a right to act in a particular way because they have been acting that way for a long period. They have been doing something for a long period of time, 20 years in this context. So where you have a thought of a complaint that an activity is a nuisance, the defendant might argue and say, excuse me, I have done this for a long period of time. There's nothing unreasonable in what I have done. So the 20 years, what that argument connotes is that it indirectly changes the nature of the locality. Oh, this noise has been ongoing. This smell has been here. These fumes have been ongoing for the past 20 years. So this locality accommodates, prescribes that activity, and you cannot complain about it. Now, we must note that ordinarily, coming to a nuisance is not a defense. If I move into a location and I got there to realize that here they are always making noise, they are always throwing a wild party every Friday, and throughout the weekend, I cannot sleep. The defendant cannot ordinarily or generally argue that I'm the one that came to the nuisance. It's not a defense. You can see the case of Miller and Jackson and Kenaway and Thompson. And then, most importantly, see Sturgis and Bridgman, which we have talked about when we are looking at the meaning of nuisance. The case of Sturgis and Bridgman emphasized the fact that the prescription, the nuisance starts when a plaintiff moves into the area. The defendant had been carrying on their business, confectionery business, using a pestle and mortar in the 1879 case. So don't be surprised when I said pestle and mortar, for over 20 years. And there was no property beside them. Then the plaintiff moved to that place, besides them, because the property was developed, and he was running a medical consultancy practice. So you can imagine when they seem to be pounding something and then he has a medical practice next door. So when he sued, they argued that they had been there earlier. He was the one that came to meet them. They've been doing what they were doing. But the court held that when they were doing it for the past 20 years, it was not a nuisance. There was no neighbor. It's about neighbors. But the moment that he came, then the nuisance commenced, and therefore prescription had not occurred. Then you have statutory authority, where a statute authorizes someone expressly to do an activity, and the inevitable result of that activity is a nuisance. Then the action will not be actionable. Okay, and this usually occurs, for instance, in statutes, for instance, under civil aviation laws, statutes that deal with railway lines and what have you, which permits aeroplanes to fly, trains to move, and whatever. So if you complain and say, oh, they are interfering in my use and enjoyment of land, it will not hold. Statutes that prescribe a right to do something are strictly construed. It must actually give that responsibility to do what you are complaining about. Then you have planning authority. Planning authority or planning permission does not. That's where a defendant tries to say, look, I obtained planning permission from the relevant public agency to build this house here, to conduct this activity, to run this factory, and whatever. The fact that you have a planning permission does not authorize or confer immunity on the defendant in a nuisance action. You can see Wheeler against J.J. Saunders Limited, where the defendant had obtained planning permission to run a pig farming business, and this generated smell which disturbed the plaintiff's property. He was running a bed and breakfast business, and the smell from the pigs, was disturbing his business. So the argument that he had planning permission was not allowed to be a defense to a nuisance action. and you have other cases in that respect. But you know, the fact that planning permission has been given to different people for a particular kind of tree repeatedly in an area can actually change the locality of the area. For instance, we turn it to an industrial area or an area that would expect that activity, that kind of interference to take place. So in the case of Coventry and Lawrence, the English Supreme Court has had held that despite the fact that there was planning permission uh, to run a racing track, it was still a nuisance. So it is not an automatic right to say I have planning permission so I can do what I'm doing. So in conclusion, with respect to defenses, you can look at those defenses that we have discussed of prescription, statutory authority, and planning permission as major defenses. There are other minor defenses which will not be considered in this video. Remedies for private nuisance. The most useful remedy from what we have described, that my neighbor is making a noise, there is smell, he's keeping a poultry, he's doing something, is to obtain an injunction in a civil action. To obtain an injunction, which is most useful. You are not really interested in damages, you just want him to stop. I want to be able to sleep. I want to breathe clean air. I don't, this smell is disturbing me. I want to, all you want is this thing to stop. So you can talk about injunction. Occasionally, you talk about damages, especially where the nuisance is the type that causes physical damage to property. For instance, vibrations from a neighbor's land causes your building to develop cracks and to collapse. So we talk about damages. In some cases, you can have abatement, a self-help remedy, that is, you try to stop the nuisance yourself, but that's limited in limited circumstances that the law permits. So in summary, therefore, the most established defenses in a private nuisance action are prescription, statutory authority, and planning permission in context. In context, it's not an automatic defense. And the remedies are injunction, damages, and abatement of nuisance. Don't forget, so these are some of the defenses in private nuisance. I would expect that you drop your comments, your questions in the comments box, and then subscribe to this channel, share the video, and like for greater understanding of the law. Thank you for listening.